Good afternoon, everyone. My name is Azizat Amoloye-Adebayo, as introduced, and it's my pleasure to make this presentation on behalf of Professor Moshood Baderin, who is unavailably absent. The title of the paper is The Role of Shari'ah in Promoting Justice and Democratic Governance in the 21st Century Nigeria. And I have here the outline. Next slide, please. The introduction, the second one is on whether Sharia in the Nigerian Constitution is a constitutional right or bias to other religious laws, and so on and so forth because of time. Now, for the conceptual clarification, it is deemed expedient to say a few words about usage of terminology. Now, in the topic, the role of Sharia in promoting justice and democratic governance in 21st century Nigeria, a review of literature or even understanding of people may be that the term Sharia is incongruent with justice or even governance. Namely that the terminology Sharia is often associated, even if in ordinary parlance or within academic circles, with the opposite of justice or theocracy, which is not necessarily democratic governance in some views. And to give an example of that in the existing literature, I refer to the view of Anyao in this work, and you can see the concern that nowhere in recent times has a question of Islamic law of Sharia produced such a crescendo of concern, posed such a challenge to the prevailing justice system as in Nigeria. So there is the belief that the term Sharia, it's an oxymoron to have it in the same statement where you have justice and where you have democratic governance. Now, we'll do a bit of analysis. Next slide, please. That the term Sharia refers to, literally, a path where water is fetched or a resource to drinkers. And in that sense of a path, the reference in that nominal terminology, it refers only once in the Quran. And the Quran, Muslims believe, it's the exact word of God revealed through the Prophet of Islam, Muhammad, on him be peace, sallallahu alaihi wasallam. And it's in chapter 45, verse 18, where Allah is referring, it's reported to have said to the Prophet of Islam or anybody that is reading the Quran, because it's worded in the second person singular. And it goes in Arabic, ثُمَّ جَعَلْنَاكَ عَلَى شَرِيعَةٍ مِنَ الْأَمْرِ فَاتَّبِعْهَا وَلَا تَتَّبِعْ أَهْوَاءَ الَّذِينَ لَا يَعْلَمُونَ. That we have placed you on a path of our commandments. Follow it and not the desires of those who do not know. So in that sense, one of the foremost Orientalists about Islamic law referred to Sharia as the highway of divine command in Islam. And there's a reason for going back to this semantics, for going back to the literal meaning of the word. And you find that the word Sharia, or what is referred to as Sharia, is contained in the textual provisions of Islam. That is, divine commandments contained in the holy book of Muslims, the Quran, that Muslims believe to be the exact word of God, and again the sayings, the actions and the silent approvals that explain and give practical sense to this textual provision. Now, there is another terminology, fiqh, and that is literally translated to mean discernment or understanding, but technically human understanding and application of the textual provision. So now, Muslims believe that Sharia is divine. area of divine command, and are not expected to interpolate anything that is human with it. But then there is the fiqh aspect, which is the human understanding and application of what is divinely perceived. Now, for provisions of the Quran, as Muslims believe are exact words of God, the accounts of the actions or explanations which becomes tradition of a prophet of Islam, Muhammad sallallahu alaihi wasallam, on him be peace, Muslims believe that even though everything that the prophet of Islam would have said to explain the Quran or to perform the Quran as elements of divine inspiration, they also know that not every account will be authentic. So authentic traditions and provisions of the Quran form what is called Shari'ah. Now, Shari'ah is considered in Islamic law as immutable because it is divine. Now, fiqh is necessarily dynamic because it's the understanding of human beings of what is textually perceived. So, at this point, Sharia does not translate simply to mean Islamic law, because it is that part of the provision as it is perceived and discerned by humans to be applied as fiqh that can then be translated to mean Islamic law. So why is this very, very important? The only court structure, the appellation for the court structure to apply Islamic law in Nigeria is called Sharia Court of Appeals, Sharia Court of Record, or Sharia Court when the area court sits on Sharia matters. So in essence, there is a court system that is described after a system that only sits on a part of that system, because the aspect of Sharia that is constitutionally guaranteed is Islamic personal law. So to then say Sharia Court of Appeal is then to say that the court is entitled, okay, to entertain anything that is connected to law as prescribed by Sharia, because the appellation is not Islamic Personal Law Court or Sharia Court of Islamic Personal Law. It's called Sharia Court of Appeal. And I'll return to that. Now, after that conceptual clarification, next slide, please. Is now the issue of Sharia in the 1999 Constitution. Nigeria is a great diversity. Sharia, as if we understand the law, Islamic law from Sharia is a religious law. So why is there a religious law constitutionally guaranteed with a court structure that is supported and funded by taxpayers' money that is not entirely composed of Muslims? So there are two arguments. That it's bias for Islam as a religion. It's bias for Muslims as citizens of Nigeria, and a review of literature would sum up a number of publications by adherents of Islamic faith and non-adherents referring to that constitutional recognition as bias. And to some adherents, it's in fulfillment of religious rights of Muslims as citizens of Nigeria that there would be a provision that recognizes even a fraction of their religious law. Now, the position of this presentation is that both arguments are not rooted in existing historical evidence. Because of time, there is no, I can't really go into the full analysis, but suffice for this presentation that Sharia is in the Nigerian Constitution, post-independence Constitution, because it had already been in pre-independence Constitution, with various names as Muslim law, Islamic personal law, Sharia law, Islamic law, or Islamic personal law. Now, because as historians have proven, the historical governors of the Sokoto Caliphate demonstrate that Sharia law can promote social justice and transparency, and so on and so forth. It's because it has been applied in territories that later came to be amalgamated into the body politic that is now called Nigeria. So Sharia is part and parcel of the historical heritage of Nigeria. It is neither to fulfill the rights of religious rights of Muslims, because that was not within the contemplation of the colonial authorities. So I'll leave it there and return to that argument later. But again, provisions in the Constitution on Sharia are listed as you can see. Next slide, please. Now, for this is about religion and diversity. Often, it's seen as things or two terminologies that do not necessarily go together. Religion is personal to people. People can do a number of things, good or bad, in the name of religion. Diversity is, in essence, requiring that there must be unifying values within the public space that is able to bring people together regardless of their personal or ideological affiliations. Now, if we talk about diversity, and Nigeria is used as an example of perhaps one of the greatest diversities. Now, is diversity a bad thing? No, because the cliche goes diversity, the variety is the spice of life, and that it creates a sense of cosmopolitan attitude in people. The citizenry are able to then interact typically with, at least in Nigeria, there's a sense that there are around over 500 tribes and lingual affiliations, and it keeps growing. So in this great diversity, it is then possible to have up to 500 different ways of attending to a single problem or challenge. Now, what is then the essence of religion? Even though, if we would say that the northern Nigeria essentially, okay, because at least most of the states in northern Nigeria have as a state law the full application of Shari'ah. What religion does is to bring a sort of unification across these ethno-lingual tribal lines, because the communities that form northern Nigeria, and I use that as an example, they are not necessarily homogeneous in terms of culture, in terms of language, in terms of ideology, in terms of the way they perceive things. But religion is able to then unify people, and it's not only about Islam, it's the same for every other religion, where people of different languages are able to come together and aspire to perhaps value their external to themselves, because religion then encourages, isn't it, that in the hopes at times of spiritual benefits, which is believed, that you then live a life of service to others. That is why the AU agenda, for example, recognizes that religious and spiritual beliefs play a significant role in the construction of the African identity. Next slide, please. Now, I then return to Sharia justice and democratic governance. Now, regardless of what may be the practical understanding or enactment of adherence, if we proceed from the fact that there's a sense of what is literally provided, which must then be humanly understood and enacted. So the fact that what is divinely understood, as Muslims believe that Sharia will be divine, must be enacted by humans in their understanding. Humans being flawed, necessarily it follows that there will be good and bad enactment. So for the objectives of Sharia, there are 5 basic necessities, and these are the baseline, that no rule of Sharia in different textual provisions, there's no time to go into them now, must be understood, applied, or even extended in a way that it offends religious rights, it offends the value of life, it undermines family, the mind, or intellect and property. And in fact, aside from these various goals, scholars of Islam have brought forth different values, which different provisions of the Quran, or as explained by the tradition of the Prophet of Islam, come together to protect. And some scholars would argue that the verse of chapter 57, 5, verse 25, that we have sent aforetime our messengers with clear signs, with the book and the balance, so that human beings may conduct themselves with equity. And the Arabic provision calls liyaquma an-nasu bil-qisti. It does not say that so that Muslims may order themselves according to what is equitable. It does not say that so that only believers. It says so that human beings, so that it is expected that Muslims are not supposed to be the only ones that will live on earth, but regardless, the equitable standard is very, very important. So what is justice and democratic governance? Anything that secures these two values will be a value that is protected by Sharia. And to say that this is not only a contemporary aspiration, I quote one of the classical scholars of Islamic law, and the slide is not up, but this guy, Ibn Qayyim al-Jawziyah, is recognized as one of the authoritative classical scholars of the Hanbali school, one of the four schools of thought, the last. And he died in year 1350. And there is this instructive part that every situation, if you would read, if it comes up anytime, that moves from justice to tyranny. That is any interpretation of any provision of Sharia that moves from justice to tyranny, from grace to hardship, from goodness to corruption, from wisdom to absurdity, has nothing to do with Sharia, even if it is presented to be so through any allegorical interpretation. Now, 21st century Nigeria and Sharia. The position of this presentation is that secularism is an outdated model of religion-state relationship, because he allowed religion to be instrumentalized. He allowed religion to be taken as a matter of personal, understanding and application. Where after understanding that the African person, the Nigerian person is a religious person, regardless of the religious affiliation, allowing or disallowing public dialogues about religion, allow people to then enact religion in a way that other people can then not hold them accountable by taking away this kind of documents from the public view. So engagement and dialogue in religious laws such as Sharia is key. And to round up, I want to commend this particular case in the American sense to the audience. And in this situation, it's also about religion in what is seen as a great diversity, where the First Amendment of the clause under the U.S. Constitution requires that there shall be no religion established as state religion. So in this case, in a particular state, Maryland, in one county, there is a cross, 32-inch cross, maintained by that national park. And some of the non-adherents of the Christian faith brought an action which went up to the Supreme Court for discontinued maintenance of taxpayers' money for the maintenance of the cross and its removal. And the Supreme Court, moving forward, said that religious clauses aim to foster a society in which people of all beliefs can live together harmoniously, and that its removal or radical alteration will be seen as many not as ritual acts, but as a manifestation of hostility to religion. So the recommendation would be that, and Faculty of Law, University of Ilorin, we already do that. If any law graduates that would come out of Faculty of Law would have potential right of appearance in any court in Nigeria, must be able to do a model that allows them to be able to make informed and individual notions based on the principles of the various law, especially religious law, so that they are able to hold religious people accountable for wrong enactment, and they can then explore situations where these various beliefs can come together for development and governance. And I'll stop here. Thank you very much for listening. And I thank everyone for the reaction and comments. And I would only say that perhaps borrowing the words of Martin Luther King Jr., that I have a dream that we can speak as Nigerians about things we don't want to talk about, such as religion, in a way that is not about me against them or them against me attitude, or in a way that we realize that we are each other's brothers and sisters keeper, that we are one. The Thank you. The presentation is on the role of Islam in promoting justice and democratic governance. Because in keeping with the theme, law, democratic consolidation and national development appropriately define the legal sources include Shari'ah, Islamic law. And I think at the points in this conference, we're going to have a presentation with the same topic about customary law, with the assumption that every other thing that we'll discuss will then be about statutory law, which forms the tripartite legs of the Nigeria legal sources. So it's not about an expansionist idea. It is also not the decision to proselytize. But my topic was not about law and religion. For keeping religion private, I'd like to make a comment that, for example, every rule of courts in Nigeria, particularly courts of superior record, have non-legal things. That is non-jury. And in accordance with those things, every Monday, that begins with an Easter Monday or Christmas Day is part of non-legal things. I'll ask my prof, is that public or private, sir? And part of my presentation is to say that, should we then accuse Christianity of that care bias? Because these are religious holidays. A Muslim would also observe. But that it is a fact of our historical heritage. Christians are not responsible in Nigeria for the received English law. It is a fact of our colonial heritage. And I hope we can have objective discussions about this so that we don't allow others to instrumentalize religion in private spaces for less than desirable purpose. And finally, on secularism, I want to give a statement I like to quote, and it's by one of the foremost personalities in the Catholic faith in Nigeria, the former Archbishop of the Abidjan Diocese, John Olorunfemi Onayeka. And he said secularism means different things to different people. And that it is fallacious because it is the same legal and political person that is the religious person. And that the sentiment do not cross, we are just being unrealistic. It is better to hold that religion and religious people accountable, and we have public discussions about them, so that you wonder about your own actions on the external others that do not necessarily or are not persuaded by your faith. So, is there secularism? I would say that even in Europe, it has been argued that secularism is mainly used to validate a particular religious perspective, to keep others silent. That in some places, like in France, which is claimed to be practicing, or which claims to be practicing a radical form of secularism, laicity, that it's in fact tailored to keep dominant a particular worldview of Christianity, even within Christian faith itself. So is it not better for we to come clean on what we're talking about, rather than encountering so-called deceptive neutral religion state models and we then descend into conflicts? I leave you with this step. Thank you very much.
Thank you very much. So